Charlie, my husband. We have our guest, Anthony Marinaccio.
Morning.
Morning.
He has been an amazing resource for us and for some of you guys over the years. He's a trust attorney, real estate attorney, evictions, property line disputes, all kinds of stuff, habitability. I call him a lot for everybody. And he's going to talk to us today about trusts and estates, and we'll talk for a little while. We can take questions at the end, and I hope you guys enjoy it.
Thank you. Thank you, Dana. Thank you, Charlie. Good morning. Again, what Dana was saying, my name is Anthony Marinaccio. My law firm is Marinaccio Law. I'm located in Glendale, across from the Galleria, if you know it. My office mostly does estate planning. We do a lot of landlord-tenant law and general real estate disputes and business disputes. So this morning we're going to be speaking a little bit about estate planning and about for people that have not done anything, and maybe if you have done something and thinking about changing it, and why it's important and what it is. So if you could do the next one. So essentially this is the life cycle of a trust. Creation, you have assets, you build something, you have wealth that you build, and then eventually you probably want to protect it and want to plan for the future. When doing an estate plan, it's not just for upon death, it's also for your life. In today's world, a lot of people are dealing with issues associated with incapacity or dementia, Alzheimer's, things where you are unable to make financial decisions any longer, and you may need to have somebody else help you with that, along with your own medical decisions. On top of that, and most people think of, when they think of estate planning, they think of my heirs, who am I going to leave things to? And everyone has different situations. So I'm going to kind of go through some of them, some of the bigger, more common ones, and for what people generally do. If you go to the next one. The planning process. I know a lot of people say they are interested in estate planning and then they come to see me, and generally the first thing that needs to be done is discuss who you want to leave things to and who do you want to be in charge. And those are two very big questions. The who you want to be in charge is usually the harder question. Generally, if people have multiple children, who do you want to be in charge as for the estate after you pass, and who do you want to be in charge possibly, if, like, for example, a power of attorney. Also, you have to think about all the assets you do have. Everybody has different types of assets. So I know we're in a real estate office, and so real estate's a big one in terms of the trust. And that is one kind of asset. Another type of asset would be, for example, retirement accounts. Retirement accounts generally kind of fall outside of estate planning in a way because those have beneficiaries. What's really important about that is make sure those beneficiaries are actually designated. A lot of people forget to do that. So for example, your 401ks, Roth IRAs, or anything like that should have a beneficiary. There's also bank accounts. Bank accounts come in a number of different ways to title bank accounts. Some people just have it individually. Some people have it as joint accounts. If it's a joint account, generally the surviving person gets that money outside the realm of the trust, outside the realm of anything else. So what that means for a lot of people sometimes add a person to an account because they say, well, that's outside the trust. They'll just get that when I die. And that's something to think about as well. And then there's also personal property. Most people, I kind of say when it comes to personal property, most people I deal with have things that are probably very low in monetary value, but very high in personal value and emotional value. Generally, if it's low in personal and financial value, not as important for the trust as it is for the just to have a list of stuff to designate, which we'll talk about in a minute. And then we have to decide what kind of estate plan you want to do. Generally, for the average person, an estate plan would consist of some sort of revocable trust. some sort of will, a power of attorney, and an advanced healthcare directive, and some combination of that. The reason I say revocable, and there's two types of trusts, revocable and irrevocable. For the vast majority of people, irrevocable really wouldn't apply to you. Irrevocable trusts generally only apply to situations where perhaps you're doing some Medi-Cal planning, which I don't really handle, or for people of estates that you're looking to avoid estate taxes. And just so everyone knows, California does not have an estate tax, and currently the federal threshold is, I think it's about 11 million for an individual and 20 million plus for a couple. So for the vast majority, again, of people, generally they won't fall within those limits to have an estate tax. If you have the next one. When we do a family information, when we come in and when we want to discuss to do your estate plan, that's when we want to get together all that information together. Your names of children, spouses, family members. And what I'm seeing a lot now, and since I don't know who's here, the crowd exactly, a lot of people I'm seeing now don't have children that I'm doing estate plans for, and that creates issues, I think, on its own. Sometimes having children creates other issues, that people have to deal with when they go in. But not having children, people really then have to start thinking about who's gonna be in charge, who am I leaving everything to? And when it comes to children, there's other issues because some people say, well, one is, I don't really trust my children with my money, or I don't really trust them to make a decision for themselves. That's one issue. And that can be helped with a special, what's known as a special needs trust. But when you don't have children, you have to think about, okay, well, who's going to be in charge? And that's when people start thinking about siblings, or if you don't have siblings, it could be friends or other family members. And I think that's when people really have to start thinking about it. I know lately I've been having a lot more people coming in with that situation. And that I've noticed requires a little more thought. Because generally with children, usually you pick one, if you have multiple ones, to be in charge. And generally I've seen equal splits or some sort of close to that. So something to really think about, even before you come to see an attorney or me or anybody, think about that. That's probably the most important thing, especially if you don't have close family members or close friends, who would be in charge. And some people use professional fiduciaries, which you can do as well, like a bank or someone that does this for a living. Or people sometimes use an accountant or someone like that, or another lawyer, just not the person who's drafting it. If you have the next one. The dog, that's true. Estate goals. Most people, when they think about doing their trust and they think about doing their estate plan, a lot of people hear the phrase probate, and they want to avoid probate, but no one really knows what it means to avoid probate. Probate is the easiest way to think of probate. It's a court proceeding that requires you to pass on things when you die. The easiest way I tell for most people to understand this is, when you die, if you owned a house, you can no longer sign the deed for that house. So that means you have to have a judge and the court decide what to do with that house. And that's the simplest way to look at probate. It's a court proceeding to determine who gets your stuff and how to sell it. It is a legal process. In LA County, it takes about 18 months to 2 years to fully go through. There are costs associated with it. It is a public proceeding, which some people don't want it to be, meaning that there's court documents that are going to get filed. It's a public record. You will be contacted by people because it is a court record, meaning that they can go by the list of names. And it takes a while. I just closed an estate that no one could wait. It was about 18 months it took, and no one could wait. And actually, out of 6 kids, 5 of them sold off their shares because they couldn't wait the 18 months to distribute the assets. And trusts can go much faster. Trusts actually, the moment you pass, you can start administering the trust within 30 days, as opposed to a probate. I mean, I've had cases that have gone both ways where people died at the same time, and we were able to close out the trusts in 3 to 4 months, and then we had the probate that was still open 18 months later, and that tells you kind of the difference. Also, there's a lot of costs associated with probate. There's court filing fees, appraisal costs, attorney fees, and the executor costs. Whereas in a trust, you can kind of limit those a little bit. When it comes to principal and income for family, some people want to make sure, for example, if you have a child or a family member or a friend that you want to leave something to, and because they need the income for a certain number of years or for their life, there are ways to arrange that through a special needs trust or through an irrevocable trust that would allow them to get some sort of income as they, after you pass. Healthcare if disabled. This is the one that a lot of people don't think about. When we talk about estate planning, and I said earlier, estate planning, most people think about once you pass and once you die. It's not just for that, it's also while you're alive. If anyone has had to deal with a parent or an older family member in a hospital, advanced healthcare directives are becoming more and more important, because if you're unable to make those healthcare decisions, somebody has to do that. Generally, if you have a spouse that's still with you, that spouse will be able to do that for you. But if you have multiple children, you can only imagine, if you had multiple children, and you will know your children best, if they could not get along and all agree on a healthcare decision, they will be fighting literally over you to what to do. And that's why you want a healthcare directive to kind of get an idea as to what you can do. And also the power of attorney, which is the same idea. It's for the same idea for healthcare, but it's for your financial decisions. I usually say it's the best way to look at it is, who's going to write those checks when you're unable to write checks? Because remember, if you're the only person on an account and you had, for example, you had a stroke, you're not unable to write those checks, who's going to take care of your bills for you and handle your finances if you're alive? The next one. So the executor, or also what's known as the successor trustee. That's what I was saying earlier. Who is going to be in charge of your estate once you pass or while you're alive, if you're unable to make those decisions? In the probate world, that's called an executor or an administrator, and for a trust, that's called the successor trustee. Generally, in my experience, what people want to think about is, who do I want to be in charge, and who do I want to have that as a backup? Because you always want a backup. And then some things to think about for this as well, is because I've lately seen this. I know some single people, when you're a little younger, people say, well, why can't I put one of my parents? But the idea is that you're going to outlive everybody. You're going to outlive the ones that are older than you, not the ones that are younger than you. So you should always go younger, not older. And the idea for that would be, you don't want to change it too often. The other, what a lot of people say is, especially if they have two kids, they'll say things like, well, why can't I just put the two of them in charge together? And I have lately I had a case dealing with these two siblings that they were both in charge. They both had to sign documents together, and they could not stand each other. They could not stand each other. And so they actually both had attorneys, and the mom was still alive. They both had attorneys, and they couldn't agree that the sky was blue. So I generally don't recommend doing two people as joint trustees, and the reason being is that you're just going to create havoc if they don't get along, especially if they both have to. It's not just one or the other, it's both of them together. They have to make joint decisions. So that's something to think about too. And that would be the person who manages the estate. So I know a lot of times people say avoiding probate, and what does a trust do? So a trust essentially it's a legal document that creates your estate. And when you pass, somebody takes the trust, usually the successor trustee reads it, and figures out what to do with it. So for example, if it says, my trust is to divide everything equally amongst my 3 children, then the successor trustee takes whatever assets there are and divides it by the 3 children. Sells the assets, divides them however way. If there's something specific, if there's a specific instruction, for example, child one is supposed to get a B of A account, that successor trustee passes the B of A account over to child number one. They basically, the trust, once you pass, the trust becomes irrevocable, meaning whatever you put in there is what it says. And so those are the directions that you'll be taking. And then of course, and this question comes up a lot, actually a lot recently. Generally, we are not responsible for your parents' debts or for other people's debts. Meaning that if your parent or another family member passes and they had a lot of debts, their estate is liable, meaning that if they had assets, that estate's going to have to pay for it. But if they didn't, there are no assets and there are nothing to collect from. So because it's important, the trustee or the executor of the estate is responsible to pay all those debts. So for example, a lot of times this comes up in medical bills when you're close to passing, that all those medical bills do have to be paid, but if there's no assets, there's no one to come after. Just because you're the trustee or the executor of an estate doesn't mean you become personally liable for the other person's debts. Okay, the next one. Depending on your situation, a big reason why people do estate planning is to designate a guardian for minors. So the way to do that is through the will. So if you have a child that's under 18, you're going to have to pick a guardian. And that's generally if both guardians, both legal parents were to pass, who would be in charge of your minor children until they're 18. There's two types of guardians. One is for financial and one is for physical aspects. So one would be essentially to take care of the child, and one is to also handle their money. A lot of times people have two different people they think of that would be in charge of money, and one would be in charge of money, and one would be in charge of the physical aspects of actually taking care of your kids. Something to think about as well for anyone that's has children that are minors. You do have to designate somebody. And again, similar to the trustee and similar to the executor, I always suggest two people, one and then a backup. And some people even do a third backup just in case. But this would only be, again, if you're co-parenting with somebody, only if there's no guardian left. So basically, both parents were to pass. The next one. And the healthcare power of attorney, which is medical directives. Something to seriously think about because people are living longer, and the last few years are sometimes being a little more difficult than they used to be. So something to think about: what do you want to do if you're unable to make healthcare decisions, and if you were to be on some sort of life support? For the vast majority of people, they say they don't want to be on some sort of artificial care or something like that for long term. You can put anything. You can pretty much put anything you want, but that's been the one that most people pick. And it's something really important to think about because and a lot of hospitals and a lot of doctors are now requiring it just as part of your care, especially if you're getting a little older because of the issues that come with it. And it really does create a lot of certainty, because what you don't want is, and I know it's been a lot of years, but there were a lot of cases in the news about families that were fighting over what to do with somebody who needed long-term care. And it also kind of provides, you could put in there things, for example, that you would want to be at your house, or you don't want to be in this facility or that facility. Something to think about as well for that. The next one. Same idea. What I was saying is that, what kind of, if you want to be resuscitated, if you don't, it's a big part of the estate plan and your trust, because it applies when you're alive. And what you don't want, and I don't know if anyone here has had to deal with anything, what's known as a conservatorship. If you have had to deal with a conservatorship, they're probably the most expensive and the most complicated things you'll ever see. What a conservatorship is if you're an adult and you are unable to make healthcare or life decisions for yourself. So for example, you've had a massive stroke and you are running a business and you're unable to run that business. Well, somebody has to go in now to court and get a conservatorship. Those are very expensive. They have multiple attorneys, even for the most basic estate. And next, I've seen estates that just completely get pillaged out of it because you have multiple people in it, people disputing things, and no one can make decisions. That's why you really, sometimes it's better to do especially the healthcare directive and a power of attorney while you're alive and well, because that's where the problems can be. And on that note as well, I always suggest, and I'm not a salesman at all, but I always suggest do your estate plan when you're well, when you're healthy, when you're well, when you're in a good mind and happy. Nobody wants to go in when you're sick, dying, not well, and having to make decisions when you're already a little distraught. It makes the process so much smoother and easier when you are in good health and in good shape, as opposed to waiting to the last minute. On top of that, and once a year we get somebody in that comes in that unfortunately they're past that point. They might not know where they are, they might not know who I am, they might not know who the person next to them is. And so the problem when you're at that point, any reputable lawyer should not be doing any sort of estate plan for you at that point, because you can't make those decisions anymore. And so it's really important. Yes, Dina.
So I have a question. Let's say somebody in here has a parent that is sort of fading or getting dementia or something like that. If they have a trust, the trust would say what happens or who takes care of them, or like what's the point where you can distinguish, or who decides when the parent or whoever is unable to like make their own decisions?
So there's a few ways to do that. One is a doctor. Most trusts, a lot of trusts I should say, have a provision in them that either one or two doctors have to make a decision whether or not you can make those decisions anymore. And that's basically when the trust and the power of attorney and the medical directive really spring into action, is when you have the note from a doctor that says this person has this condition, they're unable to make decisions for themselves. So all of a sudden that's when the trust starts to kick in, or the power of attorney, or the healthcare directive.
And if you don't have a trust and you're in that situation, then that's when you have to get the conservatorship.
That's when you'd have to,
pay all the money.
somebody has to do a conservatorship. And the way conservatorships usually pop up is that parent is sick, unable to care for themselves, multiple children usually. One child realizes a sibling is stealing money from the parents or stealing something. And that's usually when conservatorships start popping up, because people realize either they find out they've stolen all the money, they have signed grant deeds over to their properties to their kids or grandkids, things that pop up that they basically, and have left the parents out on the street. That's usually when the conservatorships start popping up, is that you have to do something to try to at least get back that money, and the other issue, not just get back the money, but the other issue is going to be to get back the care for the parent. I mean, if they've gotten rid of all their money, who's going to take care of the parent? And generally it's on that person that didn't get the money. That's the problem. So that's usually when the conservatorships start popping up.
Like people coming in who are outside of the family. Like I hear so many stories like, oh, someone has a new person at the house living there.
Yep. Oh yeah. My paralegal just last week, the neighbor got raided from what's the department? Basically the elder department for the county, because basically she was in her probably close to 100. A neighbor came in and swooped in, and I think the neighbor now owns the house. And I had a woman that was close to 100. She was living in a duplex that was owned by her father, that she lived in with her parents. So you can just imagine, it was in the family a very long time. No payment, of course, nothing, no bills. The tenant had convinced her to put him on the trust, and he was actually designated as the trustee. So then, once all the paperwork was done, the tenant started telling the owner, the older lady, that he owned the house. And technically he did. And so, these things happen when you're older, especially if you don't have a lot of family or friends around you. I see it. You see it all the time. I mean, you see it all the time. And it's getting more. I think it's always been common, but you see it all the time. Huh?
Just more open now.
More open, and just, and people, just there's more money involved sometimes, I think, so that's where the problems are. And that's what you're trying to do when you do a trust. You're trying to avoid a lot of these issues. And people even say, well, I have children, I have this, I have that, I don't have to worry about this. Well, life happens, and so you never know what could happen. Estate planning really does avoid the messes. It avoids messes in life. A very common thing that I bring up to everybody, which is kind of called poor man's estate planning, is, and a lot of people do this, they transfer assets while they're alive to their children. So for example, and I had a case involving this where an older man had a few homes and he transferred each house to his children. And he basically thought, well, that's all the estate planning I ever have to do. He didn't think this was going to happen. He died. No, I'm sorry. The father is alive. His son died. And the son happened to own the house that the old man lived in. Well, the son, when he died, unknown to the father, he had been refinancing the house and transferred it to his wife, which you can do, and transferred it to his wife, who happened to be at the moment separated from the son because he had been cheating on her. So there was no love lost between daughter-in-law and the father-in-law, and she was evicting the father from his home that he had lived in his whole life. He had no idea this could happen. He probably did not think his son was going to die before him. He did not think the wife was going to leave the son. Didn't think that the son would transfer the asset to the daughter. And this all could have been solved if they had just gone and done a trust, as opposed to, yes, as opposed to everyone thinks, oh, I'll just pay the $100 to record the deed, and that's all. Well, this happens, and no one could have ever guessed those facts. And people do that all the time, and people don't also realize when you transfer an asset to somebody, so you give someone a house, you transfer the deed, or you give them a bank account, there's no such thing as takebacks, meaning that once you give that house, you cannot transfer it back. And a lot of people don't realize that, let's say you give it to one of your children, you give it to them while you're alive, the asset. Your son did not tell you that he had a $50,000 judgment against him for a credit card he didn't pay. All of a sudden, the bank is now putting the lien on the house. People don't tell you these things. And then, or, you get into a fight one day and son sells the house and moves away, and now you have no asset. Now you have nothing. That's why you don't generally want to transfer assets while you're alive, because of this. There's no such thing as a take back, and people sometimes have regrets after they do things. And on top of that, a lot of times people do it in an unequal fashion, and so the next thing you know, that causes even more disputes later on. The next one. So again, when it talks about finances, kind of talking about all the different type of money and wealth that you could have. I kind of went through some. A lot of people, when we talk about trusts, real estate comes to mind. And it's always good to have certainty, and I think this is even more important in today's world. People don't realize, and you see this more and more, the value of your home is so high that unfortunately that usually means there's a reason to fight, because this isn't a $50,000 home that people are fighting over anymore. It could be a large asset, it could be a lot of money involved, especially if it's paid for. There's more certainty you have to that, the better. And people are going to get quite a bit of money, and so sometimes people have that concern as well. Something to also think about when it comes to minor children. I was talking about that with the guardian. A lot of people are doing things to how to split your assets if you have children or young children, or you have grandchildren you want to give it to. There are ways in a trust to distribute things at certain ages, and people do things, let's say for example, distribute everything at 25 or at 21 or at 30 years old. That's one area to do that as well. Because people do have, your assets can be pretty large when you pass, and people don't realize even the value of your own single house can be quite high. So that's why you want to make sure you do these trusts and the estate plan so that there isn't that fighting. The checking account and savings accounts we had talked about when joint, some people do joint accounts, some people put them in trusts. It really depends on you. But just so you know, when you do the joint account, that's outside of all of what we're talking about, and that person just gets the money when you pass. Meaning that if you have a joint account, like a checking account with your kid, that kid gets the money. They don't have to split it with everyone else. So some people do that. They open up small accounts and they give it to them that way. And retirement accounts and personal property. Life insurance, I recommend everyone get something, especially if you have children. You can get term insurance for the time being. That also falls outside the realm of the trusts and estate planning, because when you do a life insurance policy, you name a beneficiary and that person just gets the money. They get a death certificate, they get a check. And that's pretty much it. You want the next one? Property ownership. Bless you. So a lot of people, yeah.
Would you recommend IUL or just life insurance?
I'm not an insurance guy. I don't know. I don't know. It just depends on your situation. The reason I said term was because if you have children, generally term insurance is very cheap.
Okay.
And the long-term life insurance is a little more expensive and a little more complicated for most people to deal with. But it's good for certain people. Title to property. So if you own a house or any sort of real estate, there's a few ways you can own that property. For our purposes, the two big ones that we'll deal with are joint tenancy and tenancy in common. So the difference is when you own something as a tenants in common, you own an undivided interest, and you can give that interest to anyone you want. So if you and a partner own 50% of a property each, your 50% is your 50%. You get to give it to whoever you want.
Which one?
That's tenancy in common.
Okay.
Joint tenancy is the other way, where if you own it with somebody, the survivor gets everything. Meaning that it's the last one standing gets the property. That's important for estate planning purposes too, because I've noticed people who, like siblings, for example, that own properties together, or business partners, they didn't realize that they're in joint tenancy, and next thing you know, when it's in joint tenancy, actually I have a case right now on this, is a bunch of siblings owned a property, and the brother's the last one left, and leaving everyone in the dark, because he was the last one. And so joint tenancy means when one person dies, the survivor gets it. All they do is record a death certificate, and that person gets it. Most married couples own property as joint tenancies or something along those lines, or it's also known as a community property with right of survivorship, because generally the surviving spouse would get that property. The next one? Yes, yeah, sure.
So, how do you know which one you have?
The original deed, when you bought a property, the original deed should say it went to John Smith and Mary Smith, 50% undivided interest as tenants in common or joint tenants. If it doesn't say that, it's assumed as tenants in common, if it doesn't say anything.
So
But generally the first deed will say that.
doesn't say it. So what if you have a property and you added one of your children onto that property? Would we be joint
No,
tenants?
you'd be tenants in common.
And
Unless it says unless you added the joint tenant.
got
We
it.
can pull the title record.
Yes.
And be able to see.
look
You can find that
and
up.
give you a copy, and you can see what it says on there.
But since you mentioned adding children as tenants in common, very important for today's purposes, and I think this is more common now than it was ever before. I do not recommend ever changing the title of your property without speaking to an attorney, because you may have reassessed it. And then all of a sudden, what's going to happen is you do a deed, you record it, you gave a property to your current boyfriend or girlfriend. you gave a 30% interest. All of a sudden, 6 months later, you get a bill from the from the LA County assessor saying that now all of a sudden this property has gotten reassessed. For some people, that's not a big deal if you just bought it the last few years. But if you own this property for more than 40, 50 years, all of a sudden you're going to get this bill that is unbelievable. And you can't change that. Once you've done it, the only way to change it is actually you have to go to court and change all the deeds to go back, and then have to go to the assessors to basically tell them to change it all back. It's a nightmare. So I know we had one where the mother transferred to the children, which you can do usually, but then the kids transferred it back to the parents. There's no such thing there's a parent-child exclusion, but it's one way only. It only goes from parent to child, not child to parent. So it's important especially if you owned a property for a long time, don't touch the deeds until you talk to somebody, and talk to somebody who knows what they're doing when it comes to property tax assessments, because it can get very complicated. Even simply changing from joint tenancy to tenancy in common actually triggers a reassessment. So if they could try to squeeze some money from you, they will. So don't do that unless you have to. Yes?
Can't you do, like, on that case, that transfer of deed on death, so once you pass away, it automatically
They do those.
to that person and avoids probate?
Correct. You can do a transfer of deed upon death. Those are for, if you have a very simple estate, it probably would work. It only would apply to the property that you're doing it to and not to your estate in general. So it would just be, the question was, there's this very specific deed that's a transfer upon death deed that you can actually record now. I don't generally recommend it, but you can do that. Yes, you can do those. Because it doesn't help you with anything else in life. It just is going to be for that one property, which is possible. But again, that's where I think that's the only issue. Yes?
Going back to what you were mentioning about the example you said where the siblings had passed,
Yeah.
there was one left. How does it factor in if you have a trust with, like if those siblings were married or had
Good question.
spouses?
Good question, because I don't think I've ever, I shouldn't say that. Most parents, when they come in, if they have adult children that are married, generally they're trying to figure out every possible way that those in-laws will not ever see a penny. I can actually say that. I don't think I've ever met anyone that's actually genuinely liked them. So generally, California is a community property state. I'll start with that. Your inheritance is not community property. So for example, if you get an inheritance from one of your parents or from anybody, and they keep that money in a separate account, that is separate property. However, if they put it in a joint account and add their spouse to it, it becomes community. For example, if there's a family business, this is where it comes up a lot, like family business or an apartment building that stays with the family. If the building is a separate legal entity, so it's in a trust or it's in a LLC of some type, then generally it would be separate. But it also depends on how your child deals with their spouse. That's the problem, because you can give it to somebody. That's not the act of making it a community. It's when the child gives it to the spouse. That's where the transfer happens. So that's where it's important. And generally for smaller states, it's not the end of it is what it is. But for larger states, generally what they do is they'll do some sort of either trust planning or LLCs that keep it separate from the marriage. But yeah, that's a question everyone asks. Yes.
So if I will a property or an account to my son, is there a way to make sure that if anything happens, he can will it to his children and not to his wife? And give it to them? And
No.
that it just gets passed down?
Well, yes. You can only do that through a trust. You basically are leaving your children trusts, and the trust then terminates upon that child's death. So for example, if you have enough assets, you create a trust that basically your child will not be able to touch. the principal at least, or they could probably touch the income. They just can't touch the principal. And then that would be transferred to your grandchildren or to anyone at their death. And that generally would be separate property.
And that, so you could put that.
You can
into
do
your
that.
trust.
You can put those in trusts, but you know,
I was just
it just depends. It depends on the situation. A lot people have all sorts of different situations, and it's a good point to bring up now is that, and you can always change anything. So if today you decide to do something, when you do all this stuff we're talking about today, you can do today, and you can change next year, 5 years. And I generally recommend people change things every few years because, you know, life happens and you never know, especially if you did an estate plan when your kids were minors, for example. Yeah, of course, now the kids are 25 years old, they don't need your sister to be the trustee anymore. They probably could be their own, your trustee, for example. Or people pass and, you know, people have trust that they bring in sometimes that everyone's dead on it, been passed on it. Or, you know, you decide that you want to change who's in the trust or who gets your stuff. Anything can be changed. Why don't we go to the next one? And transfers of property, the will. So everyone always asks, well, if I do a trust, why do I need a will? Because doesn't the trust apply? Well, you still need a will for certain things, and it's important because the will is actually a document that transfers everything into the trust. And also very important, if anyone here has done a trust, a lot of people forget to put things into the trust. And so, for example, they did LegalZoom, they went to LegalZoom, they did their own trust, but they didn't record a deed that actually puts the property into the name of the trust. Or they refinanced, or they did something, and they had to remove it out of their trust name and put it in their individual name, and they never put it back in. That happens all the time. And there's a court proceeding that you can do afterwards to fix it if you have to, but it's much easier to do it while you're alive. Make sure that everything's in the trust. Bank accounts are the same thing. The bank accounts are much easier. You go to the bank, you get a certification of trust, they transfer it into the trust, and it's now there. Because remember, if you did a trust, the property has to be in the trust, not just the fact that the trust exists. Fine, the property needs to be in the trust.
One thing that happens sometimes when there is a family trust and I help somebody sell a property, but there's no bank account for the trust. So also make sure you have one of those.
Make sure the bank account, yeah.
Because you need that in order to get your money.
Right, and people forget, because remember, if the property is in the name of a trust, when you sell a property, the check is gonna go out to the trust, not to you. And for purposes of, for everyone, most people, the trust, although technically it's a separate legal entity, for all purposes, it's you still. It's you, for your tax ID number, it's still you. The trust is its own, although it's its own legal entity technically, it's still, you use your own social security number for the trust. It doesn't really change like your taxes, for example. It doesn't change. Another thing, if anyone's interested in this, it does not, the type of trust that we're talking about today for the vast majority of people do not offer any sort of asset protection. So if you're looking for asset protection, that's a separate area. That's when you form LLCs and perhaps irrevocable trusts. But for most purposes, the revocable trust doesn't cause any asset protection. Yes.
Can a home, so can a property be in two different trusts? Parts of the
Yes.
property be in two different trusts?
Yeah, you can put, for example, you own a property with someone and they put their property in their share in a trust, and you put your share in a trust. That's fine. Yes.
If you, say you have like a joint, property and you do a trust.
Yes.
And one person passes away, can that other person change it later, or is it still the original trust that you, like, say you left it to your children, but then one spouse passes away?
Okay, so generally if you do your trust with a spouse, there's a few ways to do it. One is part of it becomes irrevocable upon the one spouse's death. So husband, wife, husband dies, wife cannot change the trust. Like, for example, change beneficiaries. She can still live. She's still, it's still her property. She just cannot change the beneficiaries, and she can't change the successor trustee. And that sometimes people do that to prevent, favoritism. And generally, a lot of the stories that we were mentioning about, elder abuse apply to a spouse when the one spouse has passed, basically when someone's alone. And so that's why you want to prevent that. Yes?
When you mentioned that there's no protection, so for example, if you get sued and your property is in a trust, can they go after the property?
They can go after if you get sued for a car accident, for example, that you did yourself, your trust is still legally responsible for the debt, but an LLC would not be. So yes, it offers a revocable trust does not offer any sort of asset protection.
But if you have the LLC and LLC owns the trust, then
The trust actually owns the LLC, and the LLC owns the asset. That's what would it be? I know. So, do you have a question? Oh, okay. So that's how it would work. Let's do the next one. So estate distribution. This is where people, what do I do with my stuff? Most people leave it to the family or friends. Charity. There are some people that will leave charitable contributions. And then the government would be that's actually in a way, if you did nothing, and this happens it's a legal word called escheat, which it means that if you do nothing and you had no relatives, it eventually will go to the government. But that would only apply if you literally had no one, and no family members at all. And remember, these are all blood family members, or legally adopted, meaning that if you're from a situation where you have a very, very small family, and maybe some good friends do not have legal rights to your estate or to anything. So it's always important, if you do have especially for those who have a very small family, to even more importantly to do these kinds of things, because they literally will have, these friends will get nothing, or if you had that intent. I think there's the next one.
Question.
Oh yeah. Oh, question.
Do the family and friends need to be residents or citizens of the United
No.
States?
No. You can give it to anybody. It could be out of country, it could be here. They don't have to be citizens, no. The only thing would be sometimes a trustee is a little easier if it's a citizen, or if it's a legal, or at least a legal resident, because it's just easier to do business and to process all the work. That's the only reason it would be. And sometimes when picking a successor trustee or an executor, sometimes it's easier to pick someone that's local. We had I had a case that involved this lady. She picked somebody that lived in Connecticut, and he got a little too comfortable paying to come over here. And and also just practically, he wasn't here, and there were other family members that were much closer that probably could have done the job, and it really created a lot of problems. So that's something to think about too, especially if you have family members that all live far away. It creates a unique situation because you're far, and then that person isn't responsible. For example, that person is going to be responsible for your healthcare decisions, but what if it's 3 a.m. and you're in a hospital and that person's in, Connecticut? So that's something to think about. Next one. And the valid will requirements. And I was talking about earlier, to do any sort of estate planning, you do have to be of sound mind. And although the word of sound mind is pretty low, you do have to have it. Meaning, for example, because it's very easy, and this applies if you have a parent or a family member, if they have a touch of dementia at this point, and they do an estate plan that maybe is unequal, it would be very easy for those persons that feel aggrieved to go to court and say you've committed elder abuse. You've convinced this person to give you more than you're entitled to, and if there's documentation and there's a history of medical issues, that's a problem. Or undue influence, that could be a problem. And the other ones are, there has to be a witness, it has to be signed, all the documents have to be signed. Again, I'm not a salesman, but I will tell people, you could do your own trust and you can do your own will. You might not want to because it creates more problems, and then people realize it doesn't say what I thought it said. You know, I provide the documents and I know they're thick, and people will say things like, well, I didn't read it. Well, you should read it, and most people haven't read it. So if you do it yourself and you went to LegalZoom and did that, you don't even know what it says. Maybe you clicked the wrong box and it's not going to who you thought, or it's not who you thought or what you thought. It's really important because these are complicated and they can be thick. And a lot of times they have a lot of legal language in there that you're skipping over that might be important that you probably might not understand. And so that's why it's important, even if you've done your own, sometimes it's a good idea just to go have someone look at it. Have an attorney look at it. I always tell people, I always ask them, the first question I always say is, what do you think it said? Because I want to hear from them what they think their documents say in their mind, and then we'll find out. And half the time it doesn't say what they thought it said. So that's why it's important, especially when you do your own. You know, you click, especially on LegalZoom and things like that, you click a box or you put a name in and you didn't realize that was the person. So the next one. And estate options. Everyone has different estate options. I mean, everyone that's here has probably different living situations and different situations. You have married couples with children, you have married couples that don't have children. You have single people with children, you have single people that don't have children. And you have everything in between. Very important to think about what you need. And I know if you're reading things online, you know, sometimes each person has their own thoughts. If you're coming in as a married couple, generally I always recommend for that married couple to at least talk about it amongst themselves first before they come see me, because you probably should be on at least close to the same page to at least discuss that stuff. And I know this comes up a lot in legal presentations. I've never dealt with it, but you know, if you're coming in as a couple, another thing to always remember is that your estate plan cannot have secrets from the other spouse. It's a joint document. So if that is the plan, you're going to have a problem, because you can't have, at that point it's too late. It's too late to have those secrets. If you, like, for example, you have a secret family. Yes.
I want to tell you
Yeah.
about my secret family. No, just kidding. But can a married couple, can one person have a trust but include the other person in it?
Yes.
Okay.
Yes, I'm actually doing one right now for someone like that. Yes, you can have one spouse, and that generally is a situation where you have one spouse that had way more wealth than the other spouse, and they want to keep it separate. Meaning, because the problem is, if you have a situation where you have two spouses, one that has more wealth than the other, or came into the marriage with more wealth than the other, the issue is going to be that once you make it joint, it is now community property, because everything is a joint asset at that point. So that's why some people don't, they like to keep it separate still. It just depends on your situation, but it is possible, yes. And then that person would be a beneficiary of your trust.
There's a lady there that has a question.
Oh, yeah. Question? Oh, no, okay.
Well, I will ask this, because I come across this a lot also, is when you have two people and they're on their second marriage, and they each have separate children, or maybe if they have a combined child or children, how does that work? And how maybe they each had a trust previously and now they're married, and what do they do now? Right,
So you can have your separate legal trust that maybe you had with your prior spouse, and then you're going to have a new trust with, especially if you are married, and with a new spouse that would designate how to split things up. And you can have separate assets that are from prior to the second marriage and after the second marriage. So everything's possible. It's just a matter of figuring that out. And in a case like that, where you do have, especially when you have spouses from a second marriage, everyone's had kids from prior marriages, there's usually no love lost between children from different marriages, in my experience. So the problem is, you want to make sure it's very clear and tight as to who gets what, and what happens if one spouse dies, and what happens if the second spouse dies, who gets what. Because what you don't want, cause there will be no love lost between wife's kids and husband's kids because they don't know each other. They're all adults. Usually, if they're all adults coming into marriage, they will not have that. Usually, especially if they're all older adults coming into marriage, there'd probably be no love lost, especially if there's some money involved. So it's always good to be very clear about that. The next one. We do have this. The idea is the idea for a simple will and a trust. If you are planning on giving anything to charity or anything else, there are sometimes tax implications of everything. Like I was saying earlier, for the vast majority of everyone, the estate tax will not apply to them, at least as we're sitting here now, and probably for the foreseeable future. But that could always change. And then, but right now it's 20 million for a couple, or 21 million for a couple. So most people won't apply to that. So something to think about. If there are other generally the bigger tax implications that people are thinking about now are property taxes and income taxes. The estate tax, for the vast majority of people, no one's thinking about it anymore. But particularly property tax is the big one that people are thinking about. And there are some mechanisms that people are doing to try to keep the property tax bases low. Most of them don't work. Most of them are not working, but there are ways to keep some assets. And I know they've cut that down dramatically now, because you can only pass on your personal residence. You can only keep the property tax base of that property as opposed to multiple properties, and then also the income tax. Yes.
When you put your home, if you're under, those really nice tax system.
Yeah.
13,
13, yes.
Into the trust, does it reassess?
No, it does not reassess the trust, because the ownership, like I was saying earlier, legally it's the same thing. It's still you, and it's still you and your spouse or whoever it is that you own it. It's still the same. Everything else, though, that's what I was saying earlier. Don't touch those deeds unless you talk to somebody first, because even something silly that you don't realize will do something could change it. That's pretty much the presentation. I know I could do questions for a few minutes. Anyone? I can stick around. Yes.
To what you just said, in terms of like rental property, it's still potential reassessment.
Yes.
If you're building it out, kind of what you alluded to earlier, in terms of like an LLC owning it or something like that, does that help? Or
yes, it could. There's ways to do that with an LLC and fractional ownership that could keep the tax base low for a little longer. Yes. And I'll stick around also. My office is here in Glendale. I did leave cards in the front. Please call my office and say that you came to the presentation. They will put you as a consultation down. Generally, if you're going to come into for a consultation for your estate plan, if you don't have one and you just want to come in and draft it for the first time, I will send you a worksheet that helps me know a little bit about you. If you want me to review your estate plan, which I don't charge for those consultations, just to quickly look at something, I need a copy of the signed documents. And I don't know why lately I've had that issue where things have to be signed. And I know I recently am dealing with people that are saying that I think it's somewhere. That's important where the signed documents are. So make sure you have those. And I also do landlord-tenant real estate disputes. For the most part, I also do probate. I think for anyone here today, for yourselves and for anyone you know, it's really important to get your estate plan done. And it's also for anyone who has had a parent that has passed, either you've had a horror story or it went smoothly. And that's where I find a lot of people start thinking about their estate plan, is when they have to deal with that. They either dealt with a parent that it was a nightmare, or it went very good. Those something to think about even for your parents, for your children. I find that people that have children, minor children, it's always a good idea to get things started on this idea, because you do have assets and people have things that they should probably protect, and also the idea of a guardian, because I hate to be morbid, but generally couples, it's well known that couples generally, if a young couple is going to die, they're going to die together as opposed to separately. And so, anyway, my name is Anthony again, and the firm's Marinaccio Law in Glendale.